A married mom of three and school counselor at a prestigious Catholic high school has not only been fired, but now she faces 6 counts of sexual battery. Emily Nutley could face 15 years in prison after police say she used her position to seduce a teenage boy and coerce him into an illicit sexual relationship. We're going to take a closer look at the allegations with former criminal prosecutor Dan Schorr. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. We got another female teacher who is accused of manipulating one of her male students into having sex with her, and this time the allegation is that it happened in her own office at a high school near Cincinnati, Ohio. So Hamilton County prosecutors, they have charged 42-year-old Emily Nutley with 6 counts of sexual battery. Those are third-degree felonies, and it's our understanding if she's convicted, she could be facing up to 15 years in prison, and she would have to register as a sex offender. Now, according to the district attorney's office, Nutley was a teacher at St. Xavier High School. This is a Catholic school in Springfield Township, a Catholic school of all places. She apparently was the supervisor of a program that helped kids who were struggling academically, and she had just started at the school when this alleged misconduct reportedly happened. Authorities say the victim, a male student who was 17 years old at the time, had been assigned to the program in the fall of 2023. And that is when they say Nutley and this boy started getting physical. They were also communicating over the phone. Prosecutors say Nutley sent the victim nude photos, sexually explicit text messages. The indictment against Nutley, it isn't available to the public to obviously protect the victim, but the state says that Nutley performed oral sex on him at least once while on school grounds and one time off campus. And she also allegedly had sexual intercourse with him after hours in her school office. Now, the victim apparently tried to stop these encounters with Nutley from continuing on, but she allegedly harassed him over text messages. Officials say school administrators, they got wind of what was happening. They launched an internal investigation, brought this alleged conduct to light, and then the school had contacted the Springfield Township Police to do a criminal investigation, and now we know that she's facing charges. Now you might be asking, who is Emily Nutley? Well, she is a married mother of 3 who reportedly previously worked as a counselor at a kindergarten, worked with special needs kids at that school before being hired by the high school. Also, we did a little bit of research of our own, and we checked into Nutley using a powerful background checker called Truthfinder. And the only criminal history that she apparently has is related to not registering a dog more than 10 years ago. By the way, Law&Crime, we partner with Truthfinder. We use it to get details on all different kinds of people in our stories. But even if you don't work in true crime, this can be an excellent resource to give you some peace of mind. I mean, it's one of the largest public record search services in the United States. And with a paid subscription service, you can get access to unlimited reports about almost anyone. And right now, if you're interested, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC Sidebar. But back to the story. So St. Xavier administrators, they said in a statement to the community that they think this is an isolated incident, but they encouraged anybody who has information to come forward. In a statement, Hamilton County prosecutor Melissa Power said, "Let me be very clear. This is child sexual abuse. This child was the victim of an adult predator who should never again have a role that puts her in contact with children. She used this child for her own sexual gratification while taking advantage of the position she held. My office will prosecute this matter fully and thoroughly to ensure that justice is served." Online court records show that Nutley is due back in court on November 8th, so we will see how this case progresses. But right now, I want to bring in former criminal prosecutor Dan Schorr to talk a little bit more about this. Dan, good to see you. It's been a minute. Thanks so much for coming on.
Jesse, it's always great to talk with you. Thanks for having me on.
Talk to me about these allegations. You know, it's just, I cover a lot of these stories, and each one I think is just as shocking as the next. But what do you take away from it?
One thing is the societal evolution of stories like this, because I started as a sex crimes prosecutor 25 years ago, and we would sometimes prosecute female teachers who had sex with underage male students. And we found with juries and people in society, they weren't really taken seriously, unfortunately, that people generally saw sex abuse as having to be an older man with a younger woman, or maybe an older man and a younger boy. But the situations with an older female and a younger boy weren't taken as seriously. Now I think we're in a better place in society where we recognize that this is sex abuse, that the boy in this case, if the allegations are true, experienced situation that is highly inappropriate, can be traumatizing, and needs to be taken seriously regardless of gender. So I'm glad to see that this prosecutor is taking these types of allegations seriously, and that's a big difference than the way things used to be.
It's interesting you say that, because that comment from the prosecutor where she said, double down, this is child sexual abuse. I couldn't tell if that was because the alleged victim's 17 years old, almost the age of consent, or was a boy, is a male. I couldn't tell, but having to double down and explain that this is child sexual abuse. What did you take away from that?
I think that there's still an attitude among some people in society that if it's a boy, especially a teenage boy, there's kind of like a wink, wink, like, oh, I'm sure he's happy about that. I'm sure it's a positive for him. And I know from prosecuting sex abuse cases and working with sex abuse victims that a boy of that age can have severe trauma and problems later in life because of what they experienced if they're taken advantage of by a female teacher. And I think the prosecutor used that language to really accentuate that this is sex abuse. This isn't someone who's underage. And the older person isn't just older, but they are also in a position of power and control. Being a teacher, there is an inherent power differential between someone who's in that supervisory teacher capacity and someone who's a student. And it's hard to get away from a situation like that. If someone is a student of somebody, or in a different situation, an employee of someone, they don't have sometimes the power to get away from a situation, and that makes it even more problematic.
How straightforward of a case is this to prosecute? Because my understanding is, and I looked this up, one of the ways that it's defined sexual battery under Ohio laws, the other person is a minor, the offender is a teacher, administrator, coach, or other person in authority employed by or serving in an institution of higher education, and the other person is enrolled in or attends that institution. So that's one of the categories of sexual battery. But how straightforward of a prosecution is this?
Well, on the one hand, it's straightforward in the sense that there is what's called strict liability for a crime like this, that the notion of consent that we often think of about whether someone specifically gave consent to sexual acts, that's not part of the calculation for a prosecution. As you just said, if they're in that power position and sexual activity occurred, then that is enough for it to be non-consensual. So it's simpler in that respect. However, you still do need someone to say that the sexual activity occurred. And even though you have all those text messages, photos, but it still may come down to whether the victim here is willing to testify. There's often just emotional and other challenges to going to court and giving your story. But yes, if the 17-year-old boy alleges these facts, then it is usually a more straightforward case than other cases where the defendant can say, no, it was consensual, because the defendant can't say that in a case like this.
How do you put that victim on the stand whenever this trial would happen, if the trial actually happens, recounting what happened to him? How do you prepare a witness like that? And also, how do you prepare them for cross-examination?
Yeah, I've prepared a lot of child sex abuse victims for testifying. This boy is 17, or at least 17 when this happened. I've had victims who are 7, 8, 9, and that age. So the younger they are, the tougher it is. But you really want to explain to them that they did nothing wrong. You want them to practice telling their narrative, because it's uncomfortable for any person, an adult or someone who's underage, to talk about sexual acts in a public setting like a court. And it's really important that you explain to them how the questions are going to be. For cross-examination, often you need to have a mock cross-examination where you tell them the types of tough questions that they may be asked. It's important that the victim never be surprised by the questions that are asked. Sometimes an attorney who's cross-examining them may be rude and aggressive, and you want to tell them to just not take that personally, not react in kind, just stay calm, just give your answers. As you said before, this case may be more straightforward because the victim's credibility is probably not as much of an issue, because it's not about consent in terms of did he agree to the sex acts. The fact that she's a teacher and he's a student is enough under the law to make it non-consensual. So there may be less of a vigorous cross-examination, but that's generally how I would prepare someone for that.
And how would she defend herself by saying this didn't happen? What would that evidence look like? What would cross-examination of this boy look like?
Sure. Well, as we've been talking about, if the sex acts happened, then there would probably be a conviction, because that's enough under the law. Right, so right. The defense would probably have to be, yes, we flirted. Yes, I exchanged inappropriate texts, but we never actually had any sexual acts. I would never do that. and the allegations of oral sex or sexual intercourse, just that's not true. Although I did do other inappropriate things, that might be enough to stop someone from being convicted for the non-consensual sexual acts. There may be other consequences from just texting like that with a student, but that would probably be the nature. The defendant can't say, well, he agreed to have sex with me, because that's not a defense under the law.
I just think, and I've seen this before in sexual assault cases, not even involving minors, when you have defense attorneys who are grilling the alleged victims, the accusers, that can turn a jury off. And in your experience, have you seen it work the other way? Have you seen a defense attorney grill an alleged victim who says that they were a minor when they were abused, and it work, and the defendant be found not guilty?
I mean, certainly people are found not guilty in cases like this, but it is just tactically, one of the most difficult things for an attorney to do is to cross-examine a sex abuse accuser who's a child, because you have to show that they're not being honest or that they're misperceiving events in order to get the defendant acquitted. But at the same time, you don't want to be attacking someone who is A, a child, and B, allegedly experiencing sex abuse. So maneuvering that is really, really challenging. And you're right, it could backfire if you're too aggressive.
This would be a very, very difficult trial. I say this a lot. When you're dealing with minors who are, there's an allegation that they were abused, you don't want to put them on the stand unless you have to. You don't want to go to a trial unless you have to. So in an effort to avoid the time, the expense, the heartache of going to a trial like this, do they want to work, prosecutors want to work out a plea with her? And what would a plea even look like?
Absolutely. And I think both sides have an interest in having a plea here. The defendant is facing significant prison time. She doesn't have any real criminal record. You mentioned the dog licensing issue, but besides that, she doesn't have a criminal record that we know of. So she would not be, if she could probably arrange for a plea bargain, that would be much less severe than that. And as you said, the victim's family may not want to have him go forward with a public trial. So you could have a plea bargain. There could be a probationary sentence. There could be minimal prison sentence that's less than the maximum. They would have to, a lot of it is based on what the victim and the victim's family wants. Usually their recommendations are taken very, very seriously by the prosecutor, although ultimately the prosecutor has to make that decision.
If she took this to trial and was convicted, would she really be looking at 15 years in prison?
Hypothetically, I would say it's unlikely that she gets that because she doesn't have a criminal record in the past. Now, a judge could do anything that they want after a conviction at trial, and it's very risky to go to trial for that reason for a defendant. But I would doubt that she would get the maximum, considering that there's one victim here and that there's no criminal record. But she probably would get some kind of prison term if she was convicted at trial.
Since you've seen these kinds of cases before, I've noticed a theme as well. A lot of the people who are arrested for this, it's not like they're loners and single, they're married or they're in relationships, so they have fiancés. She's married with 3 kids. Why do we see people like this, assuming these allegations are true, engaging in this behavior?
Right. Well, we could do a whole long podcast on that topic. Just because someone's married with kids, they may be having a lot of problems in their lives. Maybe they experienced some kind of sex abuse when they were younger. Maybe their marriage is unhappy. Having a spouse and 3 children can be very overwhelming. And sometimes people either have affairs or commit acts like this because they're looking for something outside their marriage. And often it happens in an employment setting because those may be the only people that someone interacts with other than when they're home with their spouse and their kids, the people they see at work. In this case, the person she sees at work allegedly was her student. So that's extremely inappropriate. But there's a lot of things going on in people's lives that we don't know about that can drive someone to do this. And of course, she is innocent until proven guilty. So she may have a defense that explains this in a way that means she's not guilty. But those are some of the reasons that I've seen in cases like this that motivate people.
What also stands out to me is the vulnerable nature. So and that's what the law provides. Right? You're in this administrative position. You have a sense of control, and you can take advantage of a student, but also an at-risk, at Catholic school. That's the part that also kind of elevates this to a different level.
Well, unfortunately, we've seen a lot of sex abuse cases in religious institutions.
Right.
The Catholic Church cases. Every religion has had, unfortunately, sex abuse scandals. So the idea that a religious institution is less likely to have sex abuse is just not accurate based on what really happens in the world. But yes, ideally, you would think this person who is at a Catholic institution would not do something like this, but we just know from life experience that's not true.
From this limited information about the case, but the fact that the school conducted their own investigation and then that led to a criminal investigation, does the school face any liability as a result of this?
It's possible. The biggest liability a school faces here is often if they knew about a situation and they didn't take the necessary steps to stop it. So if the school had warning signs about a teacher and didn't act on it, or there were policies and procedures that were in place that they didn't follow, those are the types of things that often lead to school liability. But just the fact that she was an employee of the school could lead to a lawsuit. Often they do. Mostly these cases are settled. And we see that a lot where institutions have to pay large settlements because of what their employees did with alleged sex abuse.
My gosh, it is quite a situation. A lot of people affected. So it's not only you have to think about the alleged victim in this case, his family, but her family too, right? Her husband, her 3 kids, how they make sense of these allegations. It's hard to imagine. But Dan Schorr, thanks so much for coming on, breaking it down for us. Really appreciate it. And good seeing you again. Don't be a stranger.
You too, Jesse. Anytime. I'm always happy to talk with you. Thank you.
All right, everybody. That's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.